to make sure that everybody is signed in. Kent Washington sheet specifically. Melissa will have a separate sheet for anybody who's getting the CE certification directly there. So please sign in. If you are not on the sheet, please fill your information in the bottom so we can have record of you showing up for the class. One's for Kent Washington, so we're aware of who's coming and who signs up on membership.
No, what's the difference between the CE certification?
So
if you want continuing education, we can offer that, but that'll be a separate sign-in. I'm going to address it in 1 second.
So she'll address that then. And then everybody make sure they have company. Other than that, I want to introduce one of the people we're not saying. Lynn apparently today.
I'm told, yes.
Apparently she's Lynn. This is Elena. She's going to teach the class for everybody today. She's also the sponsor for the lunch too as well, so you want to thank her for filling your bellies as much as possible.
You're welcome. Hi, everybody. So, my name's Melissa Delana. Thank you all for having me. Before we get started, just a couple of housekeeping rules. This is an hour. We're going to run pretty much the whole time. The hope is that it is going to be conversational because this will be a lot better if you're all engaged in a dialogue with us. The Kent Washington Board was very kind to invite us to come and sponsor Lunch and Learns. As those of you who may know who are part of the Kent Washington Board, they're not always available for continuing education, but because I do maintain a school and offer continuing education credit, if any of you in this room want this next hour to be for credit, I have a separate sign-in sheet that I can send around. There is a cost because I have to charge you, not because I want to. It's $10. And I have Venmo, we can do a check, we can do cash, whatever works. So is anybody interested? Okay, I'll send it around. And if we run out of room on here, there's a second page. So I will keep this one up here in case we need it. I think we're going to. I'll send one this way too. Anybody interested for credit? To pay me, if you've got cash, great. If you don't, Venmo. If you've got a check, does anybody use checks anymore?
I do.
That is a dead marker. It's a long one, so use your little penmanship. Okay, that's the name of the school. That's who you're writing the check to. Delano Law Center for Education. Or cash. What's Venmo? I can, you can come up and get a picture of my handle. What are we at the casino? What was all that about? I might be able to make change for at the end, or you've got cash too. Mark yourself paid if you gave me cash, ladies. But we're gonna get started in the class. Oh, we got another. We'll make change at the end. You're just gonna have to see me at the end.
How about $5?
$5. We got it. We got one on sale here. All right. So, thank you all for attending. Does everybody have a copy of the handouts that I've handed out so far? You should have 2 documents. One is going to be the multifamily purchase and sales agreement, and one is the multi-unit addendum. Everybody have it? 2? Okay. You don't have one. Well, we should get you one. Does anybody else need handouts? Help a sister out, would you? Pass these back. Anybody else need handouts? Here, pass these back to the gentleman. Thank you. Okay. Are we recording yet? Oh, for God's sakes. All right, we ready to start? Okay. Hopefully they edit all that front business. My name is Melissa Delana. I'm a real estate attorney with Delana Law Office, and I have been practicing, sad to say, nearly 2 decades. I have been educating for probably about, 12 to 15 years, something I sort of fell into, but I really do enjoy and love. So if anybody after class has additional content suggestions, I'm all ears. I'm always interested in talking more about what you want to know as real estate agents. So a couple of years ago, I came up with the idea of doing sort of a deep dive into classwork. Instead of doing the traditional 3 hours, I like doing the 1 hour because I think it gives you an opportunity to really learn one particular topic, what I hope will be better than you know it when you walked in. So today's material is going to be the multifamily conveyances. And what I can tell you is that you do want to have the foundation of the standard single-family purchase and sales agreement under your belt to some degree, because obviously there's a lot of terms in the purchase and sales that we are not going to have time to discuss in 1 hour, as you might expect. So this class is going to be tailored towards understanding the nuances and specific and unique items to the multifamily transaction, okay? So, before we even get started in the purchase and sales agreement for multifamily, I want to talk about this form, the multi-unit addendum to Rhode Island multi-unit real estate sales disclosure. Everybody have it? It's a page, double-sided. Has everybody seen this form? Okay. Has anybody not seen this form yet? Yeah. Every time I teach this class, people are like, I didn't know this existed. Well, your forms committee in January of 2022, according to the date, created this document with the intention of helping our sellers who are conveying multifamily properties to give better disclosures, right? You've got the general sales disclosures, which are beautiful, but that only talks really about the building. What about if you're selling a 3-family and one unit has forced hot air and one unit has electric and one unit has radiators? I don't know, I'm making it up. I don't even know if a house can have it.
Something like that.
You did, all right, good. So I made up a good fact. You want to be able to give that kind of information and detail to the buyer in advance. It's going to help them with their inspections, and it's going to prevent the seller from having any possibility of misrepresentation actions later, which is one of the reasons that we talk about that. So on this addendum, multi-unit addendum, very much at the top, it talks about if there's a lease, it talks about if there's copies, if they're being furnished, if there's a security deposit, how much the rent is. This seems like helpful information, yeah? And hopefully you've all disclosed it, but now you have a place where the seller has accurately relayed it. And then it gets into the specifics of the individual units, such as the heating system, the domestic hot water, the electrical, the air conditioning. And then it goes on further to disclose these items. In the event that, and I just had this happen on a multifamily in West Warwick that I presided over, in the event that you have appliances that belong to the tenant's been there a long time and they've purchased their own, I would put a note in the other. Appliances of this unit, number 2, owned by tenant, not to be conveyed with sale. Of course, there's also a place in the purchase and sales agreement that I would recommend that we include that as well, because this won't count. You need it really kind of in both places. If you just put it in the purchase and sales, the buyer's gonna say, what are you trying to slip one past the goalie? What happened? Why did you do that? So if it's on the sales disclosures, you've disclosed up front that the second floor owns their own tenants, and then in the purchase and sales, you make sure you exclude it from the purchase and sales agreement, you're going to be fine. But this just happened. My client did not use this multi-unit addendum, did not disclose that the second floor tenant owned their own appliances. So the buyer was, I guess, upset, would be a way to frame it. It was a little more colorful than all that. And was asking for my client to pay $1,500 per appliance for the replacement because she was sold a bill of goods. Well, it was a mistake. He didn't do it on purpose. Trust me when I tell you, he was a very sweet client, didn't have a lot of sophistication with real estate conveyances. In fact, English wasn't even his first language. This was just an oversight. Fortunately, he had a pretty good relationship with the tenant on the second floor. So I sent him over there and said, go offer him some money to buy the appliances. I have a bill of sale, have him sign this. Now you will own the appliances, which means she owns the appliances. So we got away with it, not for $4,500, which is what she wanted. It was one $1,500 check to the tenant. And it worked very well. She was still a little upset because she didn't get the windfall she was looking for. But it is super important that you make sure that those appliances or any other nuances of the particular unit are being disclosed, not only in the sales disclosures, but also in the contract. Any questions on this form? Because we're not going to spend too much more time. Questions?
Per unit, you would make one of these?
Per unit, yeah. So that is what the intention is. In fact, at the top on the right, it references the unit.
Okay.
Which, I hate when you've got this like front and back or left and right. I mean, what happened to 1, 2, 3? It's just so simple. First, second, third. All right, so we're going to get into the guts of the purchase and sales agreement now for the multifamily. Oh,
It's not mandatory.
I just went through this. Is it mandatory? Sales disclosures are mandatory, right? Unless they're under an excludable exemption. Why wouldn't they want to do this? It makes really no sense for the seller not to do this because it's for their protection. If they're not doing this and then a misrepresentation action comes up later that they could have avoided as a result of doing it, I think they're putting themselves in some unpredictable waters. I would recommend that your sellers do it, and if they don't want to do it, they consult with their attorney, because I just had one where a buyer's agent said the sellers refused to do the per unit addendum, and can they still proceed with the closing? And I said, yeah, we can, but if there's something that's discovered later that would have been addressed in there, is the seller going to have potential exposure? I don't know, because this is so new, we haven't thought about it yet, but I think it could. Did you have a follow-up? Even on vacant? I mean, again, there may be some nuances of the individual units with respect to the heating systems and that kind of thing. Paul?
As far as the agent's concerned, then would it make sense if the seller refused to do it, just to document on that actual form saying seller refused?
I think protecting yourselves
Yeah.
is your primary job, right? Just like it's my primary job to help you protect yourselves. So I think papering everything is helpful, and putting in either unknown or refused or something. Even if you don't disclose it to the buyer, you've got it for your file that you offered it, and they're not going to later point the finger and go, well, my agent never sent that to me. Now all you have is a he said, she said situation. So, all right, so the multi-unit purchase and sales agreement. You all know it, and you're all going to love it, okay? So the first page, it's pretty much the same as the regular standard purchase and sales, so we're just going to blow by all that. We're going to go to the second page. And we are going to start with respect to section 8, which is the personal property and fixtures. See where it says in the second box, the following items, including leased or tenant-owned items, are excluded from the sale? This is where you would include second floor appliances as owned by tenant as excluded from the sale. Just like we talked about. On the sales disclosures, you mirror it in the purchase and sales agreement. So, and by the way, that box exists just the same in the single family. I just wanted to really reiterate, because there is an opportunity for tenants to have made improvements to the property, especially if you're talking about a single family. If you had a tenant in a single family home and you're conveying it with the tenant, or something that is excludable because the tenant's now vacating and they're taking their hot tub with them. You want to make sure that you are including all of that in reference, because otherwise they're going to expect it to convey and you're just going to make a walkthrough mess. And I don't want to do it. I'm tired. It's really tough out there right now, you guys. You know, right? Okay, number 9, legal units. That's really where we begin. Property is comprised of blank number legal units. How do you know how many legal units? Zoning certificate. How does one go about getting a zoning certificate? Yeah, at the town hall, zoning official, building official, you go and you write them a check. You wait a couple of weeks and they're going to give you a zoning certificate, and it's going to tell you if it's a legal 2 or a legal 3 or a legal nothing, right? I had one years and years and years ago. Thankfully it was cash, so nobody cared. But it was physically 5 units. It was being assessed as 3 units. How many legal units do you think it really was? 2. Mm-hmm. It's an ingress-egress thing. It's a situation of, is this safe for the occupants? It's a fire safety thing. So that's why we have to go through the zoning channels to make sure that we have proper documentation. It's not to say you can't make a 2-family a legal 3, but you have to go through the procedures and protocols. What you can't do is advertise it as a legal 3 and then sell it as a 2. Because what have you effectively done? Change the circumstances, right? So when the buyer finds out from the appraiser 2 weeks before closing that this is actually a legal 2, but you've advertised and contracted to sell a 3, too bad, so sad. They walk away with their deposit, and now guess who the seller's mad at? Right? It's not good. So I would recommend every single time that you are going to convey a multifamily that you talk to your client about whether they've ever obtained a zoning certificate and whether or not they're okay with you obtaining a zoning certificate on their behalf. Or just tell them that you are going to do it. Additionally, you may want to seek reimbursement for it. It's about $50. There are some communities where it's more money.
Warwick is 100.
Have they increased? Has everybody signed in for the CE credits?
No.
Okay. So we will keep circulating. Thank you. Sorry to make you do the walk around. So if there are some communities that it might be more, but it's usually south of 100 for the most part. Johnston's the only community that I know was really having a hard time because they had a fire a long time ago. And to recreate the wheel and give that, it's a lot of paperwork. I think it was somewhere around 500 for a zoning certificate in Johnston. So just don't take those listings.
I just got one in Foster, they usually charge me for it.
Where, in Foster?
Foster.
Oh, that was so nice. Did you have lunch first with them?
I was surprised. I was expecting to pay.
But that's what you would get in Foster, right? Everybody's like, they're just happy you came to visit.
Does it expire?
Does it expire? I don't don't remember how good long a zoning certificate
I
took for.
record mine when they give them to me, I go back into the town to record.
You recorded it? That was a good idea to record it. I don't think that there's necessarily a timeline in which it expires unless the circumstances have changed. You know, that's where it is, and that's why if they have one, I think you might be okay to use it, but it would be dependent on when they got it issued. So, I'm gonna have to follow back and look at my zoning certificates now. She stumped me. I hate when that happens. Fire and safety. Any questions on the legal,
I might have one.
the zoning, and whether or not you are supposed to get it or should be getting it? Because that's really the question I'm asked. Do I have to do it? No, I'm giving you a best practice. You don't have to do anything. But if you are going to do it, you can talk to your client about being reimbursed for that cost, just like you may ask them to reimburse you for the cost associated with obtaining a smoke and carbon monoxide certificate, right? Obviously, the multifamily, with respect to those, do come with special issues. Section 14, which gets onto the top of page 3, is where we are in the purchase and sales. This particular provision is actually a negotiated provision. The seller either will deliver the property in compliance with applicable fire safety codes, or the buyer can assume the responsibility. Did you know you can negotiate it? It's not how we do it in the single family, but you can negotiate it in the multifamily. So here's my question. When do you need to provide the smoke certificate to said closing attorney if the buyer is going to assume the smoke certificate? Still prior to the closing? Yeah, especially if there's financing involved. So now we start to see some possibility of issues. If the buyer's going to take responsibility for getting the smoke certificate, are they going to go into the property and have access for purposes of getting it fire compliant, making sure all the monoxide, you know, all the detectors are where they're supposed to be? What if it's a property that needs to be hardwired? There's all sorts of things to consider, and now you need to get your lender and or attorney involved if you don't think that you're going to have it in time. If you feel as though the closing is going to happen without the smoke, you may not end up having a closing. Certain lenders will not issue closing packages without smoke certificates. We have to demonstrate that we have them in advance. If it's a cash transaction and it's not a it's a vacant property, there's no habitants, we may allow for it, but it's going to be at the discretion of the individual closing attorney at that point. They may want to hold an escrow with a promise that the buyer is going to get it compliant and furnish it to us in some time later. But that's sort of an unusual circumstance. Generally speaking, the rule of thumb is you need a smoke certificate in advance of closing. If the seller's not going to furnish it and the buyer's agreed to negotiate it, they need to be prepared that they may have to go in, purchase these units, have access, and get it done. Question? Okay. All right, I think that's it with respect to fire safety. Section 15, possession and condition. So this is, again, not vastly different than what you would see with respect to single family purchase and sales. The property is still to be delivered, broom swept, and free of debris. However, it is subject to assumption of leases. I feel as though that exception is often overlooked because people just jump right to section 16 and they're like, well, we just told you it's occupied. What do you need me to bother putting that in there for? Again, it's a best practice. I'm not saying you have to do it, but you probably should consider writing in except as occupied, except as fully occupied, except for first floor tenant or whatever the case is going to be. Because now when the buyer goes through to the walkthrough, they know that those particular properties are still going to be loaded to the hill with all the stuff that the tenants own in the property. It's not going to be, free of debris. That's presumably going to be the particular unit, hopefully, that the buyer intends to occupy that the seller has vacated. That's really the one that we're kind of talking about in section 15. But again, if it's going to be a fully occupied property, 16 may have you covered, but you could always just put exceptions exception, all occupants, see paragraph 16. 16 is where it gets interesting, right? So again, you can negotiate. The seller shall deliver the property to the buyer at closing, either free and clear of all tenants and occupants, or with existing tenants and occupants that are going to remain, or other. So then we can just kind of make it up. We can figure out whatever we want it to say, right? Like first floor to remain, which intimates the other two units are supposed to vacate. But I would write that out. First floor only to remain, all other units vacant. You don't want there to be any opportunity for ambiguity. Write it out, simple, stupid. right? You want it to be simple so that nobody can not understand it. I think that it does also say seller shall notify in writing to the buyer if there's any changes with respect to occupancy. Has anybody ever had tenants decide that they're going to leave during the time that it's under contract? Yeah, so then you have to tell the buyers, right? You have to make them aware, especially if they're counting on that income. Third floor just gave their notice, they're gonna be out June 1st, that unit will be vacant. If they already noticed the first floor tenant to vacate, or maybe that's where the seller was, now maybe the buyer should know because they can decide where they're going to move, or perhaps they wanna start marketing the property. Can't actually rent it, they don't have legal standing to do so, but they could market it. They could potentially have the seller sign a lease during that time. They could even co-sign a lease if they wanted. So there are workarounds and reasons why the buyer may want to have that information. I had a closing years ago where the buyer walked into the closing and said, "You're not gonna believe what just happened. I was at the walkthrough and the tenant gave me their notice." I said, "Welcome to homeownership. This is what it's like to be a landlord, it's like you have to expect the unexpected." I think as it pertains to this provision, something that I cannot drive home enough is the importance of the seller understanding that this is a legally binding contract and they are obligated to fulfill this term however has been prescribed. So if it says there is going to be free and clear of all tenants, a text message to their tenant buddy to say, "Hey, just making sure you're gonna vacate, okay," isn't going to suffice. On June 1st, that property is intended to be empty. How many of you have had problems? I don't know if you've heard, but we've got a housing shortage, just a little one. And that is not just houses, it is rental units too. So a lot of these tenants, they may not intend to be difficult, but they can't physically leave. They have nowhere to go. And I find that it has been particularly challenging when there's pets, because most people are really kind of cracking down on trying to minimize the whole pet exposure. So it's just, unfortunately difficult for everybody. So how do you manage that with respect to sellers? What do you do?
They just have to do the best they can, and then if it puts some money in escrow to handle an eviction.
Money in escrow may be a valid solution. I think the bigger issue is if the buyer can't occupy one of those tenants within 60 days, we're going to have a potential problem with the financing. And actually, if it's a Rhode Island housing program, the overlay is they want them to move in immediately. So if the appraiser goes out and identifies that it's fully occupied and nobody's leaving, we have a different problem. Do you want to go check on that air conditioning unit over there?
I would love to.
Go for it. I can't leave the podium. They're watching. It's really warm in here.
Yeah.
So, with respect to the tenants, I think that the best practice is to talk to your seller. Make sure they understand what this provision means. Do all of you review the purchase and sales agreement with your clients when they're signing, or do they just sign, docu-loop, do whatever on their own? I don't know. I feel like people are not really committing to an answer, so I'm feeling like it may be sort of a free-for-all as to whether or not they actually do read and understand what they're signing. I can tell you, most people, when they e-sign, I watch them. They go like this. Oh yeah, it's super nice out today, isn't it? Yeah, I know. Oh, I missed one. Hold on, let me go back. It's ridiculous. People are signing contracts this way. People are signing loan documents this way. I find it repugnant as an attorney that they're not reading it. Oh, I know secretly they've never read. But in the old days, when I started my practice, we did everything the old-fashioned pen and ink way. And everybody had to be in the same place. And at the very least, we were showing you like initial here, and they had to put eyes on it to do the initials. It was a little easier than the point and click, because those phones are hard to manage. So I think it's important to pause and have a conversation with your client, not a text message, not an email, because God knows I don't read those either. But just have a conversation with your clients about the idea that they need to understand what their obligations are with respect, with respect to the tenants, and make certain that there has been formal communications and notices given. Does anybody know when notice would have to be given if a tenant had to be out for June 1st? When would you have had to give notice? April. Before the end of April.
Right.
So, and people are like, oh yeah, it's the middle of May. Yeah, we can get them out by July 1st. Can
Middle of
you?
May for July.
Maybe for July, but you're not gonna get them out for the middle of June because they think, well, we gave them 30 days, but it's not 30 days from the day you notice them, it's 30 days from their customary due date. So if they pay on the 15th of the month or the 20th of the month, you might be all right. But generally speaking, people pay on the 1st and you have to notice in advance of that date. Snail mail, certified mail. If you wanna give them a copy, if you wanna text it to them, fine. Just tell them that the lawyer is obnoxious and insist on having these writings and that they're gonna be out because they're friends of yours and yada, yada, yada. But if you don't preserve the record, there is no eviction proceedings that can start until those notices do properly go out. Which leads us right back to the conversation this gentleman wants to do, which is put me in an escrow bind, which I hate. Most attorneys hate, because how do you determine how much it's going to cost for the removal of that tenant?
Right.
We don't know how long it's going to take. Maybe we can't anticipate what kind of damage they're going to do to the unit while they're holding over. What about the loss of income that buyer is going to recognize as a result of that unit remaining vacant? It's one thing for the tenants to just leave voluntarily. It's another for them to hold over and live there and also not pay rent, because that's typically what happens, right? Now they're just mired. So it's usually a fairly large number. Anybody want to hazard what they think we would have to hold if we know that we've got an eviction pending?
25.
6 months rent, 10.
6 months, 10, 20, 25. I like it all. Yeah, we want to go bigger. 10 would be the absolute minimum I would consider holding. Usually it's going to be 15 and climbing, especially with what the costs are for attorneys, storage fees, sheriffs. Everything's like double what it was a month ago. I don't know. It just seems like the costs just keep going up. Everything, right?
So you're saying 15,000?
Easy. Oh yeah, and that's a small number. Again, it's gonna be what the parties agree to. What is the buyer willing to accept as the risk of loss to make sure that they're managing for this tenant to vacate, which the seller was obligated to do on their own and didn't?
So in that scenario, does the seller and the buyer have to agree on the escrow amount?
Oh yeah, because it's usually going to be the seller's funds that are held. I don't usually have a buyer go, yeah, I'm gonna put money aside to evict my own tenant. I
Right.
mean, that's
No,
kind of crazy,
right.
that's their own problem.
But they both must agree.
I would argue they both have to agree, because I don't want to do something that's not going to be agreeable to the buyer, and I certainly can't take the money from the seller without their agreement. So yeah, usually escrows, that's what we have to do.
And how does that affect financing? Does that affect financing if you're in the midst of
Good
this?
question. So typically the escrow would be held out of the seller's proceeds. Certain lenders, we do have to show them everything on the seller's side, so they'll have to bless it. If you have it fully occupied and now the buyer doesn't have a place to go, it could be a deal breaker for financing. If we're talking about just a bad tenant, right, one that's just not been paying, separate and apart from the unit that the buyer is going to live in, I feel like that would be less of an issue for financing, because now they're not as worried. The only problem that it could overlay, and I do everything with the idea of let's talk to the lender, let's talk to the insurance agent, let's talk to everybody so that we know everyone's covered, whether or not that could impact qualification. Because if the earnings or the monthly income was being used and now we know we don't have a tenant and we're holding an escrow and we just put it all on paper, with like flashing lights and highlighter saying, look here, lender, that would be the reason we'd want to get them involved to kind of layer into that conversation. Make sense? Okay. So, number 17. This section talks about the review of the rental agreement information. When do you, as listing agents, start the conversation with your sellers about rental agreements, lease agreements? Yeah, I would like for you to start it early, because I can tell you a lot of them don't have their paper together, right? So they may not even have copies of the documents. The other tip that actually, I can't take credit for this, I stole this from an agent in a class that I taught. One other best practice is make nice with the tenants. You need them. You need them to give you access. So the tip that the agent suggested is bring them a $25 Dunkin' Donuts gift card. Hey, I know I'm gonna have to inconvenience you a whole bunch during this transaction and I'm sorry. Just thought maybe you could go grab a coffee when I call you or text you and say, I need to be here at this time. Isn't that so simple? For like 3 units, $75, less than 100, you may have cooperation. I mean, you may not. They may be like, what else you got in there? I don't know if they're gonna shake you down, it's Rhode Island. So all I can tell you is anything you can do with respect to setting up for a solid relationship and having your proper paperwork in place with the tenant and the seller is going to make paragraph 17 a lot easier for you. So it says, 17A, the seller shall provide the buyer with a copy of all written leases or rental agreements in effect at the time, or a written statement providing the terms of tenancy, including the amount and date when the rent is due, security deposits held, responsibilities of parties for utilities, parking, and other terms of tenancy, if there's no written lease or rental agreement in place. What does that sound like?
Month to month after.
Well, it sounds like, yeah, you may, we're not talking to you. It sounds like you may have a month-to-month tenant with no lease, and that we want a writing from the tenant that says estoppel certificate. Now, this is just saying a written statement will suffice. We're gonna get to the estoppel letter in a minute. But that's essentially the same stuff. We're asking for the seller to outline everything for us if there is not an actual lease agreement or writing in place that you're furnishing to the buyer, okay? So that's 17A. Now, 17B, the buyer shall have blank period of calendar days from receipt to review and accept. How many days?
5.
Yeah, I'd say 2 to 5, you know, I don't know. In theory, you should have already given it to them. This shouldn't be a contingency that buyers are utilizing, because if you as the listing agent have done your due diligence and you've already got these writings and or lease agreements, you've probably furnished them. So certainly by the time we're outside of any inspection contingency, if people are even doing that these days, there's not going to be any get out of jail because you can't live with the rental terms. If within this period the buyer gives seller notice that the buyer does not accept the above documents, this agreement shall be null and void, and buyer shall have the right to all deposits in accordance with section 4. Of course, if seller does not receive written notice, these provisions shall be deemed waived, right? What if during that period the buyer says, you know, that rent is just way too low. I'm definitely raising the rent. What do you say as the agent?
Do it when you buy it.
Maybe. What else should you be thinking about? Do you have a lease? They may not be able to raise the rent. So as a buyer's agent, you don't want to incur any liability by saying something like, yeah, no problem, you can raise it next month. Because you may not be able to. If there's a written lease agreement, those lease agreements transfer with the property for the duration of the term with respect to all payment terms. You can't switch that on them until the lease agreement expires. Now, if they're month to month, you can absolutely propose a rental increase. However, they have to make sure that they're adhering to all of the notice requirements under the landlord-tenant handbook, which is 30 days. And again, just like we talked about for the notice of tenancy being terminated, it's 30 days in advance of their first due date payment, whatever that is. So you notice them on May 15th, they get a rental increase for July 1. You can't do it for June 1 or for June 15th, where you're trying to split the difference. It doesn't work that way. So again, it's important to make sure you're directing your buyers to the resident landlord-tenant handbook. We are very pro-tenant in Rhode Island, and it's important that the buyers understand that and have some working knowledge of how to handle being a landlord. And if you don't have landlord, units or experience as a landlord, you may want to even go so far as to say, you know what, I think it's a really good idea that you get an eviction attorney in your arsenal, because it is a really good idea. They may have to evict a tenant as soon as they buy it. You don't know. And them going it alone is going to be a scary prospect, and one that they're liable to gaff up, at least the first time. They may not make that mistake a second time, but it will probably happen the first time. Okay, moving right along. Section 18. This is my favorite. This talks about your seller obligations. Again, I don't care if you guys put it in a checklist. I don't care what you do to make sure your clients understand what their obligations are, but contractually speaking, they are supposed to be doing all of these things. And if they haven't read through the purchase and sales and you haven't told them about it, chances are they just don't know. So, seller shall transfer all security deposits to the buyer at the time of closing. Easy, right?
No.
I spent it. I don't have a security deposit anymore. Do you have any idea how often that happens? You are not supposed to commingle tenant money. You are supposed to keep it in a separate bank account. It's in the landlord-tenant handbook. Nobody reads it. So they don't know, and they already spent it. So what do they do?
Seller proceeds?
Yeah, it could come out of the seller's proceeds, but we've got to think about the lender, right? Right back to the point and place at the beginning. We can't do anything without them giving us the green light that now I can put this credit on the CD. We all know that buyers have a minimum investment, right? When they're purchasing a property, be FHA, whatever type of loan program they're in. So can we give them a $2,000 credit for deposit when they're already getting a closing cost credit and a tax credit and all these other adjustments on the closing disclosure? Maybe, maybe not. It is customary for the seller to make the adjustment out of their proceeds at the time of closing on the settlement statement. Cash deal? No problem, man. Sure. Financing? I get a lot of blowback from the lenders.
So how is that security deposit transferred to the buyer at closing then?
If it can't be on the CD? Excellent question. So anybody have some ideas?
In the microwave?
Outside.
In the microwave.
Separate contract.
It
That mean with that side?
It's not, nothing is supposed to be outside of closing between the buyers and the sellers, right? I've made the argument that I feel as though this can be outside of closing. Why? Is it the buyer's money? Is it the seller's money?
No.
It's the tenant's money. With respect to buyer and sellers, and any of us who are germane to the closing, like the attorneys and the realtors, we're not to get paid outside. It's all gonna be black and white. This is a little bit superfluous. So I can make the argument that if there needs to be a check conveyed from the seller to the buyer for this, it's okay in this instance.
Is that because you'd have to prove that that money would belong to the seller if the person actually damaged the apartment to be paid back to the seller to remediate that?
Or, yeah, or the prospective buyer.
But as of right now, there's no proof that exists, so that.
Right, as of right now, that money belongs to the
To the
tenant,
tenant, correct.
and the seller can't keep it,
Right.
and the buyer doesn't have it to give it to the tenant. So I actually did have a transaction not that long ago. This was not well planned, but this is what they did. The seller gave the tenant the deposit back. And I was like, oh, great, excellent.
They spend it.
Right, so now my buyer goes into this property with no protection if the tenant damages it or stops, doesn't make a rental payment or whatever. So now my client had to go get a deposit from the tenant. It was not a well thought out plan, but we couldn't put it on the CD, so that's what the listing agent directed their clients to do.
Could you just do that on paper, say that it came from the seller to the tenant and then back from the tenant to the buyer?
And then what? Where's the money for real? I'm not following your shell game.
No, you're saying, so I'm saying instead of doing it outside of closing, they really have the money, but instead if they can't put it on the CD,
Right.
they just say that it transferred that way.
Well, I mean, what you're talking about is just a check from the seller to the buyer. Really, because I mean, instead of going from the seller to the tenant to the tenant to the buyer,
Yeah.
you just make a direct line, right? Instead of this circuitous route.
Yeah.
So it would be fine for the seller, in my opinion, to cut a check to the buyer for the security deposit only, okay? It's much easier and cleaner if we can get it on there, but not always. Not always can we do it. So we have to figure out what those options will look like. Question? All right. Seller shall deliver to buyer a letter to each tenant notifying them of a change in ownership and an address where subsequent rental payments are to be sent and the amount of the security deposit transferred to the buyer, if any. Has anybody ever seen this done?
Yes.
You have? That the seller is notifying the tenant of the new buyer? I never see it
I
done.
made him do it.
Oh, okay. Well, you're a special blend. You read the sales contract. I can tell you the sellers didn't read it, and most of the time this doesn't happen. So the tenant gets a knock at the door from the buyer who's like, hey, I'm your new landlord. Pay me. And they're like, you're who? I don't know who you are. Because they maybe didn't even know that the property was for sale, aside from the sign out front and the nuisance. They don't know who the buyer is. They don't know that it closed or not. So it is the seller's responsibility, contractually speaking, to notice the tenants through giving a letter, and then the buyer can hand that letter over because the seller has signed it, and it's sort of this like warm handoff, right? Additionally, the seller is to provide in sub 18C all current contact information for the tenants, for all tenants, occupying the property. I would argue it should be all occupants, not just tenants. Because if you have multiple parties staying in the property that are outside the term of a lease or aren't the ones who make the payments, it doesn't matter. They will have to be noticed in the event of an eviction or any kind of rental rate change. So it is important that all occupants' contact information is furnished. And then paragraph 18D, all rents shall be considered current as of the date of closing and will be prorated according to the terms of the rental agreements and written statements. What does that mean? What does that mean? Well, it means that if you have a closing on May 15th, right, and your seller didn't collect the May rent, they are still liable to write a check to, or put it on the settlement statement more accurately, from the seller to the buyer for 50%, 15 days worth of that monthly rental income. How do you think the seller who didn't get any rental income feels about that? Not great. They pretty mad about it, actually. But guess what they didn't do? They didn't read the contract, so they didn't know about it. They may have already had a non-performing tenant. So do you tell the buyer, hey, this tenant's not performing, we're not making rental adjustments, and account for that in the body of the sales agreement? Or do you just let them write the checks? What do you think? This is that participation part we talked about. What should we do? I mean, I'm a disclosure, I'm an over-disclosure, I'm transparent if nothing else. So my feeling is if you don't disclose it, there's one coming back this way, but here's actually, pass them around amongst yourselves. Yeah,
You're saying your tenants pay on the 1st of the month.
Yeah.
You're closing on the 15th.
yeah,
You haven't received,
The May check.
right, you didn't receive the rent.
right?
So the question
You're
is,
expected to pay half of that to the buyer?
that's what the contract says, sister. You don't have a choice. I didn't write it, MLS wrote it, don't be mad at me.
Where are they gonna get that money from?
Why did they collect it?
Check the couch. I'm truly, I'm being flipped, but this is the seller's problem. This is why we're talking about this contract provision.
So you
Someone should
should
have collected on the first. Why didn't they collect?
Because the
But they're not
tenant
paying
didn't
it.
pay. The tenant's mad about the sale, right? I mean, we all know this. We've all seen the angry tenant story. So they don't want to pay the rent. I'll show you.
It would be on the seller to then go after that tenant.
Yeah.
In the legal system to get that 15 days of rent, right?
Yes.
Yeah, good luck.
I understand.
Pragmatically, it won't happen because it doesn't make any
I
sense. You're just going to spend more effort and energy than it would be worth. But legally speaking, if they don't collect the rent, they can do one of two things. You could try to amend the contract to identify at that point, this is a non-performing tenant and we're not going to be able to give you a credit, or you just write the check and count it as a loss, cost of doing business. Sayonara, thank God I don't have to worry about that tenant anymore, you know? But that is absolutely the point that I like as my favorite provision, because I can't even tell you how many times I've gotten into arguments with sellers counsel over this, where they'll say, well, they didn't collect rent, we're not making an adjustment. I beg to differ, because that's what the contract says. Unless there's a writing to the contrary, that is how it's going to be handled as a matter of course. So if you know that you don't have a performing tenant, back to my question that nobody answered, don't think I didn't pay attention to that. What do you do if you don't have a performing tenant and you're listing the property for sale?
Tell them.
Start an eviction,
Tell them.
tell them, right? Like you're just like, oh, forget it, we're gonna sell this. People are taking stuff, it doesn't matter. So you think tell them. Who thinks tell the buyer that you've got a non-performing tenant? A few. Who doesn't tell them? Okay, so everybody is in the disclosure good. Okay. I think you should be disclosing it, but I can assure you there have been occasions where it's not being disclosed that these particular tenants are not performing. They're under a lease agreement, so all they did was furnish a copy of the lease. They're not identifying that it's a non-performing lease at that point. And they may even go so far as to cut the prorated check for the rent, even though they didn't get it, because they're just like, I'm so done. They'll find out. They will find out what kind of tenant they have. And it's happened. Absolutely.
Does
So-
the buyer have any recourse on that?
What kind of recourse? They don't have to tell them if it's current.
So in
Yeah.
best case scenario, if you have a non-performing tenant and you're listing the property, you know, maybe you're in agreement or not, do you start the eviction notice?
Well, so
as the seller?
This is directionally why we're here, is that I think you should be having strategic conversations with your clients when you're at a point of thinking about listing. If you have bad tenants or non-performing tenants, do we want to strategically remove them first before we even get to market?
Absolutely.
I would argue 100% of the time, yes, that's your best case scenario, except if you are also facing active foreclosure. I only know because it's happened, right? Then you're facing active foreclosure. Because now you've got two calendars and they're not running consistently. They're running against each other in opposing directions, and you've got to do whatever is going to be best. But generally speaking, I would suggest that we start with evicting the tenants or getting the bad tenants out, whether they're slow pay, late pay, don't pay, are doing things that are illegal, are going to demonize the value of the property, make it difficult for you to be able to show it. These are all things that are only going to make our lives all a lot harder, right? And ultimately could impact your seller to a negative from a price perspective. I know that they're in a place where they want to sell the property, and trust me, multifamilies are going like, what do we have, like 6 multifamilies for sale right now in Rhode Island? What's the number? It's low. How many?
Under 100.
Is it that low?
Yep.
I was being really funny at 6, but I didn't think it was under 100. It is crazy what people are doing to get multifamilies right now. And I mean, a lot of these people are coming in from out of state, a lot of people are coming in with cash, and they're just scooping them up. So in this market, maybe you go with a bad tenant. Maybe you keep them in there because they're gonna buy it, maybe even sight unseen. But in most markets, because I have to talk about, what's not now, maybe a year from now or 2 years from now or 2 years ago, you have to be considering what a buyer is going to value. They're going to value being able to go in and see the unit. Someone who has a deadbolt on the other side of their unit and won't let you in, and they have no idea what's behind those doors, especially when there's that weird smell, they're not buying it. And it's going to impact your client's house value. So you need to have the conversation with your client up front about getting that eviction attorney in place, initiating the proceedings. It takes a while. This isn't the kind of thing that, we start today on May 16th and they're gonna be out July 1st. Oh no. The process is you have to terminate their tenancy first, and then if they don't leave on their own, you can begin the eviction proceedings. And even at that, they can appeal it. If they know the system, it can be a while before you're in a position where your clients actually have possession of that property. And God knows what the condition of it's going to be once they get in there, right? You might need a little bit of time to cover up some of the stuff, whatever it looked like. Maybe it's just new carpets and a fresh coat of paint. We hope. Yeah, you might not be so lucky. So I absolutely think that tenants do have an impact. Even the best tenants will have an impact on a sale. So you really do need to understand how to manage those tenants when you're presenting at the time of listing, talking to your landlord/seller client about what those tenant relationships are, what the tenant personalities are, and trying to befriend them in the best way that you possibly can, in my recommendation.
And there's nothing we can do about sellers that don't disclose all that up front.
What, the bad tenants? Well, I mean, I don't know. Have you had the experience, Ronnie, where you ask them and they just lie? Oh, you do? All right. Well then, yeah, that stinks. They're just bad people, I guess. But I feel like a lot of times what happens is that agents don't ask. Are all the tenants performing? What are the rents? What are the personalities? I feel like they just take it and they're like, great, got a listing. Let's go put it on go put it to press and get it under contract, right? So if you're not asking this information, then you're definitely not going to have the facts. But if you're asking it and then they're just misrepresenting it, that's a different problem. Now, I handed out one other document. Does everybody have a copy of the tenant estoppel certificate?
Yes.
All right. My recommendation would be, regardless if there's a written lease or not, there should be an estoppel certificate prepared and signed by the tenant. Now, the reason I like it is because it protects the tenant and it protects the prospective buyer. Because I don't care what the lease agreement says. Not everybody, believe it or not, reads their contracts or adheres to the terms of their lease contracts, right? So now you have an opportunity. It may say that no utilities are included, but maybe the tenant really doesn't pay any utilities and they are included. We don't want to have that kind of ambiguity when we represent the buyer and we go in on June 1st, knock on the door and say, hey, nice to meet you. I'm your downstairs neighbor, also the owner/boss. You have to start paying me, and this is what I understand the terms of your lease to be. And they go, yeah, that's not what we do here. And then what do you got? A he said, she said situation, right? This document is intended to protect the tenant and intended to protect the buyer. So you need to express that to the tenant, that this is something you want to be their friend. You want to help protect them because you want to make sure nobody later is going to try to impose any new terms or look to the current lease agreement or industry standards to what is going to be used. Like for the idea, I would say most leaseholds do not include utilities. Would you agree with that? Most. But it doesn't mean that they didn't negotiate it. I just had one the other day where the third floor heat was controlling the first floor heat unit. And I'm like, well, that's ridiculous. But if you have two different tenants on two different floors, hopefully you disclose that first and foremost, because it may be something the buyer wants to cure. But as a result of necessity, how are you going to split up those utilities between the first and third floor? It's just like, makes my brain hurt a little bit. How are you gonna do it? You're gonna take the bill and split it in half? Third floor is smaller than the first floor. I don't know, but the third floor controls the heat for the first floor. It's just weird, but that is unfortunately what you guys have to deal with, especially in these, triple-decker type multifamily situations that sometimes stuff was add-on. It may have been a third floor attic that was converted, and this was the only way they could get it to work. So I would suggest giving a copy of this to the perspective or to the tenants with your, buy-in of the gift certificate, and ask them, hey, listen, I would love it if you would take a few minutes and review this. If you have an attorney or someone that you want to talk to, your priest, whatever, bring it to them. Have your parents look at it, whatever the case. This is intended to protect all parties. I'm going to need it signed close to the closing date. Do you think that will be an issue? Great, thanks, sport. And then you can move on about your day. What you don't want to do is get it signed right then and there on the spot in February, and now we have a closing in May, and I go, it says they last paid February's rent. What happened to April? What happened to May? Because now I don't know. So you do need this document to be fairly timely to the closing, within the month of the closing, kind of like what we deal with on resale certificates and all that jazz, right? Any questions on the estoppel certificate?
Say you represent the buyer and you're not given that, can you, not
If
given
you
to
are
the
a buyer's
buyer,
agent, you should absolutely be asking the attorney if an estoppel certificate was requested. I can tell you on every single property, when we send out our, welcome listing agent, we're the closing attorney, we include an estoppel certificate and say, if there are any tenants, we want all parties to sign this. And then we have to follow back because we know you don't read our emails and say, were there tenants? What happened? Where's the estoppel certificate? Can you pull over? No, you're driving. All right, let me just send it again. Because we know this game. I've seen this show, all right? We know it's not getting to the sellers or to the tenants to do it, but there are offices, ours included, that we do not want to close without an estoppel certificate because it's putting too much risk on the buyer without having this done. So as a listing agent, you should absolutely have a copy of this in your files so that you can present it to your your current tenants. And as a buyer's agent, you should absolutely be asking as we're getting ready for closing, right? Hey, did you get a smoke certificate? Did you get that tenant estoppel letter? Did you, get the water meter reading? All the stuff that needs to happen before we can have a successful closing, just put that on your checklist to make sure you're micromanaging your co-broke.
So you're saying to put it in your listing packet to give to them or whatever.
I would.
But then you want it signed closer to the
Right.
closing.
So ultimately what and again, you may have a landlord who's like, oh, I've got a great relationship with all my tenants, give it to me, I'll get it signed. And they might. But you need to express to them, well, we can't sign it now. I mean, right now, sure, sign it now. We're gonna list it today, we're gonna close on it like in 26 days. Whatever everybody wants, right? Because that's just what's happening right now, it's wild. But on average, you would list it, you'd have to go maybe, I don't know, a month. What did we do in November? Was it like a month? Was that about the average day on market? And then you have to get it under contract. Then you have to have the closing after you go through all your periods. So maybe you've got a 2-month gap. Right now, it's a lot closer in time to the day you take the listing. But in a normal market, it's going to be a couple of months. So you're just gonna give this to them and say, a couple of weeks before the closing, I'm gonna come around and look for this.
But how can we put it in, oh yes, because it's.
You're
going to
just
the seller.
yeah. Explaining it to them.
Yeah.
You're just setting the table.
Yeah.
There's no food yet. Just look at it. Okay? We're gonna sign it later.
But what if the buyer wants to see it?
If the buyer wants to see something signed by the tenant, they're not legally entitled to it according to the sales contract. They're just entitled to something from the seller. But you could ask the tenant to execute it, date it today, and just say, hey, we're gonna update it in a couple of weeks. And if they're fine, or in a couple of months, if they're fine with that, I'm fine with that. Okay? You don't wanna make it too hard for them.
Where do you find the forms?
So if anybody wants a copy of this form, I can email it with the certificates if you're on CE. If not, and you want a copy, you can email me and I'll send it to you. There's also also one on MLS, and for the love of God, I don't remember the name of it. It's not called an estoppel certificate. It's called like rental something.
Confirmation.
What is it?
The confirmation of rental form.
Okay, so there is an MLS version of this. It just looks different because I think mine's maybe a little more comprehensive. So I think.
And it doesn't include who it's being sold to.
It doesn't include what?
Who it's being sold to.
Yeah, it's more,
More of just the tenant.
it's more generic. Yeah, it's almost, I think it's almost to be used just to disclose who the tenants are. Do the tenants still sign it, Crystal?
Yes, the
Okay,
tenant sign it and the owner.
and the owner signs it.
It's the confirmation. of
Melissa, I
rental.
just gave these tenants on one of my listings, and I had information based on what was in the lease that they signed.
Yeah,
And they all were given a full tank of oil by the landlord when they moved in, which the agreement said that they would.
they have to replace it.
Well, the tenant argued with me when I gave it to him, and he says, well, we have no oil, we're not putting oil in. I'm like, well, you signed that you had a full tank of oil.
Right.
It's still bad.
And that's an interesting issue Janet just raised is that, and is it duplex?
It's a duplex.
Yeah, this happens a lot in duplexes where they both have their own oil tank with the understanding that they have a full tank of oil when they take occupancy and they have to return the oil when they leave. And, presumably they've replaced the tank more than once during the time that they've owned it. So she's saying that right now the tenant is arguing that they're not going to replace the oil. So who do you think is going to have that problem later?
The landlord's gonna have.
Yeah, the seller landlord is going to have to deal with either filling the tank or leaving it empty and not getting a credit for the fuel. But you can't let it go down to the place where nothing's operable either. I don't know how far along you are in your inspections. Maybe there's enough in there for now.
Cash.
Are the tenants leaving?
Cash is, when the owner takes occupancy, he's gonna give them 30-day notice.
So the new buyer is going to come in, take occupancy on one side and then kick out the other side?
Yeah.
Probably the oil won't be an issue because the time of year doesn't demand oil
Right, 'cause they
and
have electric hot water.
yeah, I would think that, the buyer can get in, there's no inspections like you said,
Yeah.
and then
And
they'll
the
just,
seller's okay with not getting the.
There'll
credit.
just
She
be no
wants them
credit.
out. She wants them out. She's
Right.
like, whatever.
there was one more section that I'd like to touch on, but you guys can read it amongst yourselves because it's really simple. It's section 19 that talks about violations. If there's any violations that come up against the property, that the owner is obligated to notify the buyer and each tenant of that. Again, something that I don't see happen regularly, but that is what the contractual obligations say. So I think that concludes our time today. Does anybody have any questions?
Great class.
Thank you. I hope you found it helpful. If anybody did not sign in for credit, see me. And if you owe for credit, see me. Thank you.
Thank you.
Thank you, good job.
Thank you.
Thank you, everyone. Thank you.
Thank you.
Class. I do have some housekeeping portions before you all take off on me. The first one is that this is recorded, obviously, and this is a utility that you all have access to on the Washington website. You, all these lunch and learns too as well. If there was something maybe you missed and want to reevaluate again, they're all on there. Plus all the other classes that we do on a monthly basis, they're all listed as much as possible. There is a survey next to the signing sheet over here, if you can take a moment just to fill that out before you leave. It also asks for ideas for future classes, if you do have something. Kent Washington Education Board meets once a month, try to come up with lunch and learns throughout the year, cover the entire thing. Right now on the docket, we have RPR set of classes coming up in summer. It's going to be July and August. It's going to be a 3-part series directly with that, so that you don't have to take the entire RPR training. You can get the tools, the understanding of the tools that happen from those. So that'll be the next one. We also have one in June that we're trying to plan right now. It's still not finalized. That'll probably be around June 8th if it does get done. But thank you all very much for coming. Hope you have a great rest of the week.
Thank you.
Oh, thank you. Do I owe you something? Excellent. This will help.